The shocking truth about waivers: most people don't understand before the activity begins. Someone hands you a piece of paper. You skim it. Maybe you sign it without reading a single line. After all, it's just a formality, right? But then something goes wrong: a serious injury, a trip to the hospital, mounting medical bills, and suddenly one question becomes incredibly important. Did that waiver you signed just destroy your right to sue? Most people assume the answer is either a simple yes or a simple no. The truth is far more surprising, because in many cases, the legal power of a waiver depends on details hidden in the fine print. Details that can determine whether an injured victim receives compensation or walks away with nothing. And what courts have ruled about these agreements may shock you. Most people treat waivers the same way they treat software agreements. They scroll, they skim, they sign, and they move on. Whether it's a gym membership, a trampoline park, a zipline adventure, a recreational sports league, or an outdoor activity, waivers have become a routine part of everyday life. In many cases, people barely glance at the document before putting their signature on it. After all, how important could it really be? The answer, from a legal perspective, is very important, but probably not for the reason most people think. The biggest misconception about waivers is that they provide complete protection from lawsuits. Many businesses believe that once a customer signs a waiver, they're protected from liability. Many customers believe the opposite, that signing a waiver means they automatically lose all legal right. Both assumptions are often wrong. In reality, waivers are far more complicated. A waiver is essentially a legal agreement in which one party acknowledges certain risks and agrees to limit or waive specific legal claims. The purpose is usually straightforward. Some activities involve inherent risks. Skiing involves the possibility of falling. Rock climbing involves the possibility of injury. Contact sports involve physical impacts. Businesses want participants to understand these risks before participating. That sounds reasonable, and courts often agree. But here's where things get interesting. Signing a waiver does not necessarily give a business permission to act carelessly. This distinction is one of the most misunderstood concepts in personal injury law. Imagine a person signs a waiver before using a climbing facility. While climbing, they lose their grip and fall despite proper safety procedures being followed. The business may argue that falling was an inherent risk of the activity. The waiver could potentially strengthen that argument. Now imagine a different situation. The facility knowingly uses defective safety equipment. Employees ignore maintenance requirements. Management fails to repair obvious hazards. An injury occurs as a result. Suddenly, the legal analysis changes. The focus shifts from assumed risks to potential negligence, and that's a critical difference. Courts across the United States have often distinguished between accepting the ordinary risks of an activity and excusing negligent conduct. Exactly how that distinction is applied varies from state to state, but the principle frequently appears in waiver-related litigations. That's why attorneys rarely evaluate these cases by asking only one question: was there a waiver? Instead, they ask a series of questions. What did the waiver actually say? Was the language clear? Was the participant given adequate notice? Did state law allow the waiver to cover the circumstances involved? Did negligence play a role? Was the injury caused by an inherent risk or by something that should have been prevented? The answers to those questions can dramatically affect the outcome of a case. Another factor that surprises many people is how closely courts examine the wording itself. Not all waivers are created equally. Some are carefully drafted. Others contain vague language. Some clearly explain specific risks, others rely on broad, generalized statements, and when disputes arise, wording matters. A single sentence can become the center of a major legal battle. Attorneys may spend months arguing about what particular language means and whether a participant truly understood what rights they were giving up. For businesses, poorly drafted waivers can create vulnerabilities. For injured individuals, carefully reviewing the language can reveal opportunities that weren't initially obvious. And then there is another layer that makes these cases even more complicated. Certain situations may involve minors, Others may involve gross negligence, reckless conduct, or public policy concerns, and when those factors enter the picture, the legal landscape becomes far more unpredictable, because some of the biggest waiver cases in America weren't decided by whether someone signed a document. They were decided by what happened after the signature and whether the law believed that signature should actually prevent accountability. This is where waiver cases become truly fascinating. Because despite what many people believe, a signed waiver is rarely the end of the conversation. In fact, it is often just the beginning. When an injury lawsuit involving a waiver reaches court, judges don't simply ask whether a signature exists. They examine the surrounding circumstances, they analyze the language of the agreement, they consider state laws, and they evaluate the conduct of everyone involved. That's because the law generally tries to balance two competing interests. On one hand, people should be free to voluntarily participate in activities that carry known risks. On the other hand, businesses and organizations should not automatically escape responsibility when preventable harm occurs. Finding that balance is where many legal battles begin. One of the most important factors courts often examine is the difference between ordinary negligence and more serious misconduct. While laws vary by jurisdiction, courts may be far less willing to enforce waivers in situations involving gross negligence, reckless behavior, or intentional misconduct. Why? Because society has a strong interest in encouraging reasonable safety practices. Allowing organizations to completely avoid responsibility for extreme misconduct could undermine that goal. Another major issue involves clarity. Courts frequently scrutinize whether waiver language was sufficiently clear and understandable. If important terms are buried in confusing wording, hidden in dense text, or written in a way that an average person would struggle to understand, disputes can arise over whether meaningful consent actually occurred. After all, signing a document and understanding a document are not always the same thing. Then there are cases involving children. These situations can become especially complex because minors generally cannot enter contracts in the same way adults can. As a result, waiver disputes involving youth sports, recreational programs, camps, and similar activities often involve additional legal questions that don't exist in adult cases. And this is where the biggest misconception about waivers finally falls apart. Most people think waivers operate like an on-off switch. You signed it, case closed, no lawsuit, no compensation, no legal options. But reality is rarely that simple. A waiver may strengthen a defense. It may limit certain claims, it may influence negotiations, but whether it ultimately prevents recovery often depends on the specific facts, the applicable law, and the circumstances surrounding the injury. That's why attorneys carefully investigate these cases instead of relying solely on the existence of a signed document. Because the signature itself is only one piece of the puzzle, the conduct of the parties, the nature of the risk, the wording of the agreement, and the events leading to the injury can all play critical roles. So the shocking truth about waivers is this: they are powerful legal tools, but they are not magic shields. A signature can matter tremendously, yet in many cases, what happened before the injury and what caused the injury matter even more. And that's why some people who signed waivers still recover compensation, while others discover that the document they barely read becomes one of the most important pieces of evidence in the entire case. Now we'd like to hear your opinion. Have you ever signed a waiver without reading it carefully? And after learning how these agreements actually work, do you think businesses should receive stronger legal protection? Or should injured individuals have more opportunities to challenge waivers in court? Share your thoughts in the comments below. And if you enjoy uncovering the hidden realities behind personal injury law, liability disputes, and the legal documents most people never think think twice about, subscribe, and turn on notifications. Every week, we break down the legal questions that can change the outcome of a case long before anyone steps into a courtroom.